ఇక్కడ పెడతారు. అదే వస్తాను చూసుకో. నెక్స్ట్ క్లాస్
హలో హలో Yes, occupy your seats. I have few questions for discussion. Enter the classroom. Quick. ఏం శర్మ ఎవరిని విన్నానన్నా జనరల్ గా బాడీ ప్రెసెంట్ మైండ్ అబ్సెంట్ గా ఉంటుంది. ఇప్పుడు నీ బ్యాగ్ నీ మైండ్ అక్కడ ఉంది. నీ మైండ్ అంతా బ్యాగ్ లోనే కదా ఉండేది. ఆ? అవును అవును బాడీ ఆల్సో ప్రెసెంట్. ఈ కాన్వర్సేషన్ ఇవన్నీ మిస్ అవుతాను. అట్లా చెప్పదు శర్మ. ఎందుకట్లా? ఎంత ఆనందం చూడు. లాస్ట్ డే మేడం 5 ఏళ్ళు విముక్తి దొరుకుతోంది. ఆ? నీకు 3 ఏండ్లు. ఎస్, settle, be quick. Let me have a discussion with you regarding a few cases and all. Yes, ఏం అక్షర అక్షయ అయిందా? సరే, pay attention to the question. Kiran, an LLB degree holder, pay attention to the question. I will not repeat more than twice. Kiran, an LLB degree holder, aged 20, aged 20, submits an application before the Bar Council of Kerala for enrollment as an advocate. Listen to the problem, understand, and then answer. You need not note down. You need not note down, Mr. But the Bar Council of Kerala rejects his application. Rejects his application. Advice. Who will answer this question? Just raise your hand. You will be given mic. Huh? Just understood the problem? Huh? Yes.
According to section 3, according to section 3 or 4 of the
Continue. ఇక్కడ ఆఫ్ చేశాను.
according to section 3 or 4 of the Advocates Act, the minimum age qualification is 21 years. So that he cannot enroll.
He cannot.
He cannot enroll.
Should he wait for 1 more year?
Yes, ma'am. Till he attains 21 years. According to the statute.
According to the statute.
But there are provisions where many persons has enrolled here. Yeah. There are other things for 1960.
Ma'am, he can complete the degree in LLB in 20 years.
They can complete, madam. Like child prodigies are there. Where they have, with the prior collector's permission, they might have written 10th exam, where by limitation,
Even in
years like that.
Even during the 7th standard,
Yeah.
they have appeared for the 10th.
And at that time, they will have composed the same law degree, so that they can definitely be able to complete before 20 years or before 21 years. So completion of degree is not important. The enrollment is important here. So according to the norms and conditions which were there in Advocates Act, BCA regulations, rules were there. So 21 years is the criteria of the eligibility to get the certification of practice COP of advocate after initializing of the passing of exam A. So we are not even allowed to write the exam of A. How can we get like practicing advocate COP or like?
COP has come now. According to the present, this so. Whether an issue could have raised with regard to the admission process and all. Yes or no? Only if the candidate has satisfied all the conditions can take admission to a law degree. There is for 5 years, 10 plus 2. For 3 years, 10 plus 2 plus 3. In the absence of 3, a diploma can be considered. Avana? So here, a person aged 20 can be given permission to. This is what you mean to say? You mean to say. So the age criteria is taken.
Not the age criteria.
Uh,
In the age of 20 years, he won't complete 10 plus 2 plus 3 plus, that is 5.
mm.
Okay, LLB degree, if you will complete it in 5 years and 2 years of plus 2, then 10. It will be 21 afterwards, so we can complete.
And Ramjan completed like that only, madam. He became practicing advocate at the age of 19 itself.
19.
The education standards at that time was different. And now,
Even now also Saina Pragati Jaiswal is there, who
During
completed her law degree same in the same manner.
while schooling itself, they might have got double promotion. Double promotion. Exceptional cases. Exceptional cases. So I am on valid. Switch it off. Enrollment. That's all. That's what. Can he apply for enrollment? Is the question. Whether the objection made by the bar council is valid or no. According to statute, it is valid. According to statute, it is valid. The switch of them. Statutory provision says so. Another question for you. X, an advocate, X, an advocate, appeared in the court in a drunken state to present the case of his client, but the judge prevented him from presenting the case. Is he entitled to any remedy? Anyone from third row? Third row. Fourth? Girl side? అర్థమైందా problem? Advocate appeared in the court in a drunken state to represent his client. Is it permitted to do, or it amounts to professional misconduct? Contempt of court. Contempt, misconduct and contempt of court. What is that?
I like the answer.
It's not clear.
If we have an option, alcohol is there in that also.
See, that is a self-generated alcohol. Okay,
Sir,
that is not an
I
alcohol.
can have sleeping pills, madam. Even that is also intoxication. The perfect, like, whenever we are using an interpret that is a drunken state, not only drunken drive will be, like steroids are there. If we inject it, it is also getting, the main intention is whether we have positive intoxication or negative intoxication.
Drunken state.
Sharma, don't go in deep.
See, drunken state. The question is so clear. He entered the court hall in a drunken state. Whatever. If he is under medication, he has to get it represented through someone. Fair, a fair procedure. Taking advantage of the ignorance and illiteracy of the client. என்ன தூங்கிட்டு இருக்கியா ரிலாக்ஸ் ஆயிட்டு இருக்கியா கேடா what happened to you ஜன்னல் பக்கத்துல உட்கார்ந்து ஹாயா ரிலாக்ஸ் பண்ணிட்டேன் கதையா சொல்லிட்டு இருக்கேன் நான் கல்லூரியோட படுத்தேன் taking advantage of the ignorance and illiteracy of the client, an advocate demanded money from him on false representation that it was required for court purposes and the advocate misappropriated the money. What is the remedy available to the client? You have to play dual role as a client and as an advocate. Answer. Okay. You can use mic.
That client can approach the court to appoint another advocate for representing this case. Because the advocate comes under misconduct of professional.
Any other remedy?
Yeah, he can claim compensation for that.
What compensation?
Professional misconduct. Advocate get more money, so he can approach the court to get compensation.
Now, now presume, now presume, switch it off. Are they off check? Now presume you are an advocate. How will you defend yourself?
Based on my experience, based on my experience to conduct that case, fees varies.
The client have all the proof of the amount given to you. The client have all the proofs. Okay, transactions, shadam kani, whatever it is, and how much you have spent. The account detail shows clearly that misappropriation happened. How will you defend your case? Will you take this as I am a very senior advocate, I have experience in this, and so I can demand whatever the amount I want? Can you take that as a defense? புரியுதா சொல்றது அங்க ஆஃப் பண்ணாதான் இங்க நான் யூஸ் பண்ண முடியும் இல்லனா எப்போ அவ்வளவுதான் அங்க ஆஃப்ல இருக்கா there is a clear evidence presume that I am your client I am an illiterate man okay and so I have given the amount whenever you demanded and asked I came to know at later date that you have misappropriated all the money which means your misappropriation is you can use the money for the purpose, actual purpose, the minimum amount, and the maximum is Swaha money. Presume this is just an example, okay? And so later I came to know about all this. What is the remedy I have against you as a client? I have a remedy because my money is with you and you have not properly utilized it for my benefit. For your own benefit, you have used maybe. Okay. So one remedy just tell me the remedy that is available to me as a client. And now I am an advocate. I have taken your role. How should I defend the situation? Should I accept the blame of misappropriation, or what is the solution? క్వశ్చన్ ఆన్సర్ దొరకడం కాదు, బుర్ర ఉపయోగించి తప్పించుకోవడానికి ప్రయత్నించాలి.
Even though a person is literate or educated, he won't have enough idea about the case for mortgages and fees and all. An advocate is collecting the amount as a consolidated amount for the fees and the advocate fees also. Then how can we uh, divide the advocate fees and all fees? And how can be considered as a malpractice?
Here, off. I just highlight the sentence, okay? An advocate demanded money from the client on false representation that it was required for court purposes. It was required for court purposes. Stages that dig out to the petition file చేసినప్పటి నుంచి వకాలత్ ఫైల్ చేసినప్పటి నుంచి. So
This false representation and for purpose, all these are narratives of the person. It's not the case of the architect's position is different.
no.
I am on defense. I am on the defense side.
Ah,
I am
your
correcting.
defense,
I am correcting.
your defense must be so strong. We'll continue. We'll continue the problem.
Now, this is my narrative is I am collecting the amount of my fees which is up to me and my standard. And I am collecting that much amount and all fees and everything I am paying from my fees only. I am collecting a consolidated fees and how can it be in the separation of these things? That's box fees and other fees.
You please off the button there. Off it. If you have a valid proof of all the accounts, the amount which you received from your client on different dates, and for what purposes you have spent the amount that you received. If you have a proof, then you are on safer side. That is the reason accountancy is required. Basic thing, right? So, taking the blame or rejecting it on valid proof depends. How strong you defend your case, how strong you are in proving the evidences and all. That shows whether you are an honest advocate or not. We'll continue with different cases at later date.
Here only this here, where is it? Wait, wait. Switch off that. Shall we move forward? Today we are going to discuss. Today is the last class, and today we are going to discuss about victim, victim and criminal justice system. Silence, please. If you will not maintain silence, you know my nature. This mic will immediately reach you. This will immediately it will go there and disturb you. Please maintain silence. Let us learn the unlearn things. That is my policy, my principle. Let us give time. That's why we are here. So today what we are going to discuss? Victim and criminal justice system. Before entering the subject matter, one question came to my mind. One question came to my mind. I thought I will ask my students what is their idea regarding that. What is their idea? What do you mean by that? What is your idea? That question that is only for you. Regarding this subject, regarding this subject, regarding today's topic, so not from cricket, IPL, or not from any other topic. Because we are discussing penology, victimology. So my questions is based on this subject, today's topic. Today's topic. So what is that questions? If you have answer, kindly say yes. If yes, then I will. My next question is why? How? You will tell me. Okay. The question is, kindly read this question. Keep the questions in your mind. I will ask you. Kindly raise your hand and tell me. Understood these questions? What is the meaning of these questions? What does it mean? What I want to know from you? Do you think? Do you think? Please read it. Let us discuss. Don't read. Let us discuss. The question is: do you think sentenced to undergo any form of punishment complete the wheel of criminal justice? I am telling you. I am telling you. My question is: a person committed a crime. The state apprehends the criminal, offender, wrongdoer, the violators of crime, and bring to the court of law. If the court found guilty, the court will awarding punishment. Isn't it? That punishment to the offender is complete the wheel of criminal justice. No.
Good morning, sir.
Yeah.
The law is a very way public society will be living that things are happening. And the court procedure system, criminals, punishment, these are all coming into play. everything will be there. The person committed mistakes and court is punished given and given the time to the civil court or criminal court the criminal. As per the rule, as the criminal procedure, they are punished by the court. But your question, do you think your question is morning, the one question, do you think any of the punishment committed the criminal justice? Yes. Why from taking this now? Very beginning in the bird creations or people creations, there is no court, only law under the kings and the Grama Panchayat like this only. That time also, any committed mistake person, they will realize what with the they will not commit crime again. But after development, all this completed short question is punishment complete deal of the criminal justice. My idea is when criminal is punished by the court by the means of all the ways, after that he released the crime will not completed. I can say my answer no.
Anybody want to share your idea regarding this question? Thank you. According to me, it is yes. Why? Because there is no punishment. Definitely, the crime will be more. The law, actually, the law is right. Any offense, punishment should be there. Practically, the criminals are created from the jail. It becomes profession. It's not a mistake of the law. It's mistake of the administration or else it indicates in the administration, but not with the punishment and law. No punishment, definitely can be. Can be solved. Have that.
I think this punishment will give a satisfaction to the victim and also give a message to the society that not to repeat these things, otherwise it will be a situation.
Partly caused in questions. Anybody else from this side?
The basic question is here, does the justice prevails when punishment was given? So I say, I want to say completely as no, because the justice is not given on the part of victim. Because the punishment only was given to the offender. That doesn't seem to be justice.
Give big hand, please. Mr. Sharma rightly pointed out, gave the right questions. You both are those who attempt really praiseworthy. You attempted your level best to give your answers. But Sharma, what he rightly said that the criminal justice deals with both the offender and the victim. Victim. So when we are awarding the punishment to the offender, my question was, does the wheel of criminal justice complete? If your answer yes, my question is, then what about the victims? You see, when the state apprehend one offender, the criminal, and during arrest to sentence to the jail, the court of law, the police administration, criminal justice administrations always they were thinking about how to give punishment, whether he has convicted, he was involved in this crime or not. how to escape or to avoid punishment or to escape, relieving from this blame game, isn't it? But they are forgetting about the victims. I will say that. Now, as I told you that in this modern era, once upon a time, victim was the forgotten man in the criminal justice system. Once upon a time. Now, the law has been changed. If we'll study the evolution, the genesis, the growth, the development of criminal justice system, now they are focusing on, concentrating on giving the importance to the victim also. Is that it? Victims also. That's why Law Commission constituted by the government of India, the minister, they recommended, they suggested the different how to address the victims, how to protect the interest of victims, how to give him or her rights, his or her rights, his or her rights. That is the point that we are going to discuss from these questions. We are going to discuss the plights of victims in India. As I told you that once upon a time, please correct yourself. Once upon a time, there was no time on the part of the judiciary or the police to concern, to think of about the victim, only how to arrest, how to give him punishment. That is the idea. Now this idea has been totally changed. But before that, as a part of our study, let us have a look towards this plight of the trouble, the problem of the victims in India. As I told you that the punishment to the offender. Earlier, this concept was there. Punishment, giving or sending him to the jail. That was the main point. If he found guilty, if he was involved in criminal activities, that was no. So those questions. Let us start our discussion from that point of view. So the historically, victims were often the marginalized, ostracized by the society, by the criminal justice system, ostracized, downgraded, downgraded in criminal justice process, relegated or the downgraded to the sidelines of the as the focus center of, because earlier as once upon a time, the then period, that the entire criminal justice focused on the offenders, whether he committed that crime or he is an innocent person. The court duty was to prove his guilty. Whether if he is involved, then we will give punishment. So entire criminal justice was centered or where towards the offender, not towards the crime. So, and the legal aspects of crime. So in India, once upon a time, victims have always been ignored, being neglected, and not given sufficient legal rights and protection required for justice. Now, also this is a new concept, witness protection came. Earlier, there is no such concept, witness to give protection to the witness. So when the court realized that why the witnesses are not coming forward to give their witness, because they are fearing. If I will stand against one rich person, my life will be in danger. So they are not coming. So this new protection, this witness protection, they will use. Witness, the police will provide the protection. So that is the process of the second. Moreover, with the increasing rate of crime and delay in disposal of justice to the victims, it became necessary to make the victims focal point now of